Hello, and welcome to Stowe Talks, a podcast designed to support people going through relationship breakdown and all of the challenges and difficulties this brings. I'm Matthew Taylor.
And I'm Liza Gatchell, family lawyers at Stowe Family Law. And today we're going to be talking about cohabitation. So, cohabitation is the fastest growing family type. And in a nutshell, it usually refers to unmarried couples who are in a relationship and living together. So, according to the Resolution website, because I did a bit of Googling before today, there are currently 3.3 million cohabiting couples. 1 in 5 couples cohabit, and 46% of couples believe in the common law marriage. So I think, Matt, that is a really great place for us to start because
Yeah,
you
isn't it
46%. I mean, how many times do we as family lawyers have to shout from our, rooftops that there's no such thing, and yet that's still a high proportion?
Yeah, it really is. It really is. So, that's the beginning and the end of it. There isn't one. Sometimes people talk to me and they say that they filled out a form on a website, and you can say that you're single or married or divorced or common law, you're in a common law marriage. So it does exist. I've no idea why. It's never been a thing. It's not something that applies in this jurisdiction. And it's really dangerous because the rights, and we'll talk about this in a bit more detail, the rights that you have to claims, sort of financial claims on divorce, and the rights that you have to financial claims upon the end of a cohabiting relationship are like light years apart, aren't they?
Yeah, they are. So do you want to break that down for us then? What's the difference?
Sure. So people who've listened to a few of these podcasts will probably be familiar with the sort of claims on divorce. But if you're divorced, then the family court can look at effectively all the finances of the marriage. Look at your properties, look at your pensions, look at your investments, cars, sofas, your collection of China dolls, or whatever it is that
Dog.
your dog or pet nobs. There's an episode for a future podcast. And look at income and look at making maintenance orders. Now, if you're cohabiting, firstly, the family court can't get involved at all other than claims for children. So when we talk about cohabiting rights, we're actually dealing with civil law. So this is not part of the family court. This does not fall under the kind of statutory heading of the, and the Section 25 factors that we've talked about in terms of finances on divorce. So your claims for cohabiting couples are either property-based or they're claims for financial provision for children under Schedule 1 of the Children Act. Now, very briefly, under Schedule 1 of the Children Act, what the court can do is make orders for provision for property for children and for payment of school fees and for lump sums to pay other costs, so furnishing properties, and for orders for child maintenance in specific circumstances, normally when the non-resident parent has an income above £156,000 a year, which is the child maintenance service maximum. But those aren't claims for, the mum or the dad of those children. So what claims do cohabiting couples have themselves? Well, there's no claim to pensions. There's no claim for cohabitant version of spousal maintenance. Your claims are limited to what interest you can establish normally in a property, or if there may be a business or some form of other agreement, a joint savings account, something like that. So it's completely different. It is, a completely different area of law. And I think the real key thing is that the best way to describe it is on divorce. What a court's got to look at is what's fair. Okay, the court has to achieve fairness, and fairness isn't a concept that really applies itself in any way to cohabitants' claims.
So predominantly, I would say when we're dealing with cohabitants' claims or disputes between cohabitants, it relates to properties.
Yeah.
So how do those come about?
Okay, so there is a statute which is we're going to call TOLATA. We're going to call it TOLATA because its full name is too long to say. It's the Trust of Land and Appointment to Trustees Act 1996. And that is the piece of law that governs joint ownership of property. I'm going to try not to make this too boring because this is boring. This is very law-y. So I'll try and keep it light because I can practically hear people switching off as I'm talking. So there are two ways to hold property in joint names. You can hold it as tenants in common or joint tenancy. And it's about the share in which you hold it. It's really about survivorship rights as much as anything. And when you hold property jointly, it's held on trust. So you have the legal ownership, whose name is on the property, at the land registry, and that'll either be a sole name or joint names. And then you have the ownership of what's called the beneficial interest. So that is the actual value in the property. So the best way that I have to explain this to clients is I have a bank account. I've got two little boys, and I've got bank accounts for both of them. Because they're only little, they're 8 and 6. They can't have bank account in their sole name. So I have the bank. I am legally owning the bank account, but they have the beneficial interest. So I am holding the money for them. So it's my name legally on the bank account. I'm trustee of that bank account for my kids, but they have the beneficial interest, the value. And properties are the same. So whose name is the legal title, and then who's got the beneficial title and the actual ownership of the property. And disputes arise because of that. There may be dispute where a property's always been in one person's name and they've lived together for a number of years, and then they separate, and the person whose name isn't on the property says, well, I've got 50% interest in that property because we always said it was a joint property. Or it may be a situation where a property was purchased in joint names and one person put 80% of the deposit in and one put 20% of the deposit in. And there's a dispute arises as to whether they should get the 80% back, or is it 80% of the deposit and then split the rest equally, or is it 80% of the whole thing, or is the whole thing just 50-50? And the way in which we establish those varies hugely from case to case and what the situation is. But it depends on actually what was done and what was signed at the time of purchasing the property. And to the extent that there's a dispute, particularly around the sole names properties, what the common intention of the parties was. And I'm not going to talk too much about common intention constructive trust, because again, even more people just switched off then. But what you're looking to do is establish that a trust has been created sometimes where the intention of the parties was the property was held differently. The fundamental point is that is not about fairness. That's about what was intended by the parties at the actual time. So a great problem in this is you can end up in situations, there have been many reported cases about it, where parties can be together for 50 years. And commonly the woman who will lose out. Commonly, traditionally the man would own the property, payments would be made, the man would be going out to work, pay off the mortgage. The wife would, there you go, I'm falling into a trap. Not wife, that's the whole point of this. the female partner would raise the kids and then they would separate. And the kids have grown up, so there's no claims for the children. What claim does the woman have? In a lot of cases, they don't have any, and they're left high and dry. So that's one of the great problems with these. So I think that, is there anything I've missed there in terms of the common cases that come to you, Lisa, when you're dealing with inquiries from cohabitants?
No, I don't think so. I guess one thing to discuss is just my personal view is there's just a whole lack of understanding when people purchase properties or make contributions to properties, pay for extensions or make mortgage payments, etc. There's a complete lack of understanding as to what that means from a legal perspective. And often there are assumptions that parties make, which may actually have no basis in law. And I don't know about you, but I've bought a couple of houses with my husband, and my experience of buying property is that when you're buying it jointly, quite often you just get sent out an A4 piece of paper and you're asked to tick a box. Do you want to own the property as joint tenants or tenants in common? And, from what you were just saying there, actually, the result of which box you tick is incredibly important. And it's really, really important that you fully understand the implications of that. But I don't think most people do. And I think that's the problem. And that's where we then end up having to pick up the pieces when parties separate, because they didn't understand the implications of those decisions that they made 5, 10, however many years prior.
Yeah, absolutely. And that they can be really complicated. They can rely on recollections or documentary evidence from years and years and years ago, properties purchased in, 10, 20, 30, 40 years ago. Evidencing things at that time is very difficult. The costs are very front-loaded. You're dealing with civil proceedings. So if you lose, you're probably paying the other party's costs to some degree. So they're huge and high risk. So you really want to avoid getting into these disputes if at all possible. So how can someone avoid getting themselves into this absolute pickle of a mess, Lisa? You find out, you start with the point of, joint tenants in common. What's that mean? It's the education piece. What can you then do from that point to protect yourself?
So joint tenants and tenants in common is very much a legal concept where you're buying property jointly. Joint tenants effectively means that you own the joint, and you were talking about the joint beneficial title, that you own those, and it's equally in most cases. Tenants in common means that you would own the legal title equally, but you can own the beneficial title in other percentages.
Exactly. So it's separate percentages, and that can be 50%, can't it? You can agree
It
to
can be.
have it tenants in common. But if you're doing the tenants in common thing, there are a number of documents that you need along with that. So there's two really important things that I think we should discuss with people. And the first is a declaration of trust, and the second is a cohabitation agreement, and those two can work together. So, if someone's coming to you, or perhaps you've got a friend who's saying, "Oh, we're buying a property together," what sort of things are you telling them about, declarations of trust and cohabitation agreements? How can they be useful?
So it's about being very clear as to what your intentions are. Because as you were saying, one of the issues is trying to find out what the parties' intentions were at the time. And your declaration of trust and your cohabitation agreement will very clearly set out what those intentions are. So the declaration of trust predominantly relates just to the property. So it will basically say how you intend to own the legal and beneficial title of the property. The cohabitation agreement, however, can deal with all sorts of things. So it can deal with payments towards mortgages, payments towards bills, how you're going to split contents. So very much perhaps a bit like a prenup, but it's much wider. So it can discuss any issues with the same idea that you have these conversations up front. And hopefully it means that if in the unfortunate circumstances where the relationship does break down, you're not going to be arguing about these things, because you both fully understand what your intentions were and what's going to happen to the various assets.
Yeah, absolutely. I think that's a really good summary. The declaration of trust relates to ownership and property beneficial interest, and that's traditionally something that a conveyancer would do at the time of purchase and would say, it's 20/80, it's 60/40, whatever it may be. Cohab agreements can be really valuable things because it can be really flexible. And you can say that, we own the property 60/40, and therefore we will pay 60/40 to the mortgage. Or you can say you're paying to a joint account together. And what can be really useful is you can specify, and a lot of this sounds fairly miserable because you spend the whole time talking about the end of the relationship when you're doing something which is fundamentally really exciting, which is buying a property with normally someone you love, or it might be a friend, or it might be a sibling. But you are saying, well, if this doesn't work out, if one of us decides the property should be sold, what are we doing? Are you giving one person the opportunity to buy out the other's share? Are you just saying it goes on the market? Do you both have the opportunity to have sealed bids? If it's a sole owned property, let's say we're buying a property together, Lisa, poor you having to live with me. But let's, if we're buying a property and it's in your sole name and you've got 90% interest, we might decide that actually what would be fair is, because you've got the biggest financial interest in that property, if you decide to kick me out on the street, then I will, decide the relationship's reached an end. Within 2 months, 3 months, 6 months, whatever it is, I will leave the property and you will be able to buy out my 10% interest. So you can put those mechanisms in place, because there are a number of cases where you can have disputes about who retains a property. And if it's 50% interest, you can have court proceedings with both parties saying, I want to retain the property. And there are a number of things that the court can do. It can just say, well, I prefer that one of you should have it because there are all these factors under Talata, one of which is the welfare of a minor child, and that can dictate a primary carer staying in the property. Or the court can just say, well, you can't make your mind up, so we're going to sell it. Or it can say sealed bids. There's all sorts of things that the court can do in those circumstances. So a cohab agreement just provides absolute certainty. And it comes back to not what's fair, but what was intended. And as you say, it's a really clear kind of demarcation of what that intention is, I think, from the starting point.
Yeah, I mean, the other thing to consider, I suppose, for cohabitees and protecting their interests is, we're going to get morbid again now, but death. So what should they do? What's the difference there with married couples to cohabitating couples, and what types of things can they do to protect their interests?
Yeah, so the starting point, let's look at joint tenants and tenants in common with jointly held property. There's a big difference between the two on death. Joint tenancy, if a co-owner of a jointly held property and the joint tenancy dies, the remaining co-owner will receive the share of the property. It won't pass through the deceased estate. It goes automatically to it. So me and Lisa, joint tenants, and then I die, Lisa gets my share, and vice versa. If it was tenants in common, we'd have our own distinct shares in whatever proportion. And if it's joint tenancy, actually, you can sever the tenancy, and then it becomes 50-50 on a tenants in common basis, or whatever proportions you might agree. if that were to happen and I were to die, then my 50% share, rather than going direct to Lisa, will pass into my estate and be distributed according to either the terms of my will or the intestacy rules. So wills, we're family lawyers, we're not wills lawyers. So this is very much an overview. And getting a will is really important for a variety of reasons. It's really important on divorce as well, and if you're having a relationship breakdown. But if you don't have a will, there are some automatic provisions. And if you're married and you don't have a will, the intestacy rules provide that the first port of call is things going to your spouse before your children, then your parents, and it goes out and kind of, it's like ripples on a pond going wider and wider out from your own kind of you being the center of your family. Intestacy rules for cohabitants are really limited. Something else that we talk about pensions a lot on this podcast. Cohabitants have got very limited and very different rights in a lot of cases under pensions. So these are problems and things that need to be looking into, because it's a very different legal status. Under the law in England and Wales, the rights of married couples trump cohabitants significantly, which, in some ways may be right, in some ways may be wrong. And there's a lot of debate, I think, in family law circles where generally that most family lawyers would feel that cohabitants are given a bit of a raw deal, and perhaps the law hasn't kept up with the development of society. Our marital laws, the divorce laws, just changed in 2022, but actually the law that sets out the division of assets on finances still dates back to the Matrimonial Causes Act 1973. Property law, we talked about Talat's 1996, and before that we were relying on statute really from 1925, Law of Property Act. So it's really historic stuff. And even in that kind of 25-year-ish period between 1996, the way in which the family unit structure in England and Wales has changed has been spectacular. Kind of back to your stats at the start about the growth in cohabiting couples. So Lisa, perhaps you can outline what changes could be made, have been mooted to be made, or do you think should be made in terms of giving cohabitants rights under law, and what are the arguments kind of for and against that?
So it's a really tough one, isn't it? The law is complicated, without a doubt. You've said it. And I think, certainly there is a lot of push to simplify it to a certain extent, so that people will really understand what the rules are, and provide more options potentially. So there's been a lot of push for it. We don't have any specific reforms as far as I'm aware. Matt, you can jump in if that's correct.
No, well, back end of 2022, the government rejected proposals that were made for the reform of cohabitees' rights. So at the moment, it's not really in prospect. I mean, there has been talked about various proposals over time. Which would, and I think maybe to put it in a bit of context, is England and Wales is sort of fairly unusual when you look at similar-ish jurisdictions. So a contrast is often made with Australian law. And if you're in Australia and you are a cohabitant, you can, under certain circumstances, qualify for what's called a de facto divorce. I'm not sure if that's a legally specific term, but an Australian lawyer contact of mine certainly always called it that to me. And you have certain rights in terms of wider assets of the relationship, whether it's savings, whether it's pensions, whatever, if you've lived together for a certain period of time. So there are calls, and personally that I would support, in giving cohabitants kind of enhanced rights. But it's about finding that line, isn't it? Because being a cohabitant is different from being married. It is different from being civil partners. There is a very valid argument, which is that, well, people have chosen not to be married, so therefore why should they avail themselves of the rights? And there's a very good reason for married couple property rights not applying to cohabitants. But it has been mooted that there might be, for example, an opt-in or an opt-out system where couples can choose, actually what we want to do is we do want to opt into the system, which would give perhaps a financially weaker party claims to some sort of share in the equity, because otherwise at the end of a 50-year relationship they might be left with nothing.
But I guess it's the whole playing devil's advocate, isn't it? So if we're going to have an opt-in, opt-out system, then isn't that the same as opting in or opting out to marriage?
I think that look, there's definitely an argument to that, but you're opting into something that is essentially weaker and less so. You're looking, rather than on marriage, we apply the sharing principle in a lot of cases, don't we? The starting point is add up and divide by 2. It's not always the final outcome, but that's the starting point. I don't think there's a suggestion that giving cohabitees that sort of level of rights is necessarily going to be appropriate. But, if you're playing devil's advocate for the purposes of this argument, if I'm representing, I'm going to pick my most sympathetic client here. I'm representing, of course I am, a lovely little old lady who has slaved away raising a family and hasn't really had a career of her own and hasn't developed her own pension. And then her partner ups and leaves her, and she's left with the state pension and effectively no cash and no assets in her sole name. How can that possibly be right? How can, after contributing to the life of the family by raising the children, be then left with nothing and left falling back on the state and really not much else in future? I don't see how that can be right, and I don't see how that is properly protecting people, especially in a situation whereby, maybe let's really extend this. My little old lady came to me saying I'm a common law wife, and I had to start the conversation with, no, you're not.
But is that not the issue then? Is it not about education rather than imposing rules and laws onto people because they have been effectively in a relationship for 5 or 10 years? Is it not the case that we should be providing more enforced education at the time of purchasing a property so that it's much clearer that parties understand the implications of what they're signing up to, and then making the enforcement avenues in those situations a little bit more straightforward?
I mean, I think you're absolutely right. The party should be aware of what they're going into, and it should ensure that they've had some sort of, I think education on going into a marriage about the impact of divorce is something equally important, because how can you know what you're going to end up with? You're signing up to something you don't know the outcome of. So I think that's absolutely true. But there are still very, very, very many cases, and we've spoken here on this podcast about economic abuse and people who have just been forced into a situation in their marriage and their relationship where they don't have financial control and they stay at home. And why should those people be prevented from having some sort of something to take away from the end of the relationship that they will really need, that will serve to meet their needs? Because as the law stands, we consider that parties have needs at the end of a divorce.
It's not a divorce though, is it, Matt?
Well, exactly. Well, I don't think it makes a lot of sense for us to say that parties don't have needs at the end of a cohabiting relationship. I struggle to draw the kind of the common thread between those two, because either the laws and in this jurisdiction, we recognise that people have needs that should be met from jointly held resources. Why does that only apply to what was the almost enforced family setup dating back hundreds of years because of the way that marriage has developed in this country? Why does that not apply to now the fastest growing, way in which people choose to organise their lives now?
Potentially, the difficulty with that is that when you get married, you're signing a marital contract. So you are contracting into, and again, whilst a lot of people may not fully understand the implications of that contract they're signing, you are signing up to that agreement and the sharing of assets and all that comes with it by signing the marriage certificate. And it may well be that the 3.3 million cohabiting couples that we spoke to at the beginning, that we talked about at the beginning, it may well be that the very reason that they haven't married is because they don't want to contract their finances together. So, I mean, we're looking at both sides of the coin here, but okay, I've got a magic wand. I'm going to wave it. How would you change things?
So I think that actually the combining the education with the opt-in or opt-out system, and I'm in two minds whether it should be opt-in or opt-out. I could be persuaded either way on that. But I think there should be a recognition of the fact that financially weaker cohabitees who have contributed to a relationship for a period of time, and that could be a sliding scale. You could get, that you could increase your share over 3, 5, 10 years, whatever it may be. There should be some right to share in the benefits of particularly property wealth, but potentially also pension, depending on the factors, on the end of that relationship. Now, if, let's say for the sake of argument, that's an opt-in system, then upon, buying a property, that would be something that could be provided. There would have to be an education campaign to let people know about the requirements, and you can opt into that. And if you choose not to opt into that because you want to keep your finances separate, then all well and good. unless there's evidence of any kind of duress or fraud or mistake, or those normal kind of vitiating factors, especially linked to economic abuse. You could have it. I'd probably favour an opt-in, actually, because my own personal belief system, my own personal ideology is I would always favour, protecting the vulnerable at the possible risk of unfairness to the person with more assets. That's a personal view, but I'm not going to criticise anyone who takes another view. So I think some sort of ability to meet needs. Now, I wouldn't go as far as sharing. So just coming back to what we talk about in divorce, there's sharing and there's needs. And, on a longer marriage with jointly held, with marital assets, you're looking at sharing principle. On a shorter marriage, perhaps, or when there's non-matrimonial wealth where it's inheritance been kept separate, that can only be used to make needs. I can't personally envisage a very strong argument, and I'm fully ready to prepare for someone to convince me otherwise, why those needs shouldn't apply at the end of a cohabiting relationship. So I would have some sort of lesser provision, whether it's an opt-out or an opt-in, that would allow the financially weaker party to have their needs met. What about you?
What if needs though meant that they needed more than 50%? So you've got somebody that's purchased a property, that, maybe they, I don't know, had it 20 years prior to the relationship, they have paid all of the mortgage, they've done all of that, and then they have hit the 10-year criteria or whatever it is. And we have a needs assessment, because let's be honest, when we're looking at divorce, the vast majority of cases that we deal with are needs-based cases. It's not very not very many that we're actually dealing with a 50-50 straight down the middle sharing. Is it fair that in those circumstances that the property, and where they, one party does own that property, they've made the decision not to get married, they've made the decision not to have a declaration of trust or put the property into joint names, is it fair that we then look at a needs argument that means they could potentially get half or if not more of the property?
I mean, I think on cohabitants' rights, I'd struggle to envisage fairness being done where you've had the opportunity to set out your finances. I'd struggle to envisage a situation where fairness is represented by more than 50%, because fairness swings both ways, doesn't it? And needs swing both ways, and the financially dominant party will have needs. So I probably struggle to get that far. I think it would have to be a minority share, particularly if they have, chosen to opt out, opt in, whatever you have. And there's been documented discussion of people making an informed choice. And if people made an informed choice not to go along with the system, and that leaves them worse off in the long run, that's kind of on them. There is a degree of personal responsibility to it. But I think that those cases are going to be probably lesser than and do less damage than the case of people being, my little old lady who's, who you're leaving in trouble if you're not waving your magic wand. So what would you do? I'm going to magic wand back to you. Are you saying people should lump it and tough, and you either choose to put a property in joint names and do a declaration of trust, and if you don't, it's on you?
I think it's a really tough one, isn't it? I think ultimately we need to be able to give parties a choice, and it shouldn't be enforced upon them. I think there's a lot of misunderstanding around what marriage actually means, and it's not just a big wedding where we get to wear nice dresses and have a big party. It is a contract. It's a relationship contract that provides financial implications. And, I think there needs to be a huge amount more education about what that is and the realities of that, and also for people that are purchasing properties outside of it, so that they can make an informed decision, because we already have, to some extent, an opt-in, opt-out system. You can opt in to financial sharing by getting married, or you can opt out of financial sharing by not getting married and living as cohabitees. And that is a choice that some people make. Some people will choose not to get married for that very reason. And so part of me does feel that it's then unfair if, as a state, we say, well, actually, because you've been because you've been in a relationship for X number of years, it's now, we are deeming it fair that you give up X percentage of your assets. And, that in itself can then cause all sorts of problems with people separating, I don't know, the week before that time limit's due to come up, or kicking somebody out, or all the rest of it. So I don't know if there's a right answer with a magic wand, if I'm honest. I think the current system doesn't work. I'm not going to sit here and say that the current system works and it's perfect, because it absolutely isn't. I do. Certainly the cohabiting system needs to be reformed. But I do wonder whether going as far as imposing an opt-out, I am slightly uncomfortable with an opt-out system, that it's imposed unless you opt out, because again, I think there just will be a lack of education. And so what we'll find is that there are lots of people that just haven't realised that they've fallen into that category. And I think these need to be informed choices. These are adult relationships. It's personal finances, and both parties need to be able to make an informed choice, and we need to have a system that allows for that and provides parties to fully understand what the implications of those choices are.
I mean, either way you look at it, there isn't informed choice at the moment, because of all those people who think their common law spouses are not making an informed choice because they may believe they are in an opt-out system already by virtue of this common law myth. So it's really difficult, and I can see it both ways. I understand where you're coming from. I'm just going to stick with my little old lady over here, and I'll put my arm around her and try and look after her while you're being the big wild wolf.
I feel like I need to come up with a sob story now.
No, there's no sub story.
Counteract it. Well, I might have a client whose parents both died. He or she has had an large inheritance from family. It's all the money that she's got. They left it to her because that was going to be her financial security moving forward. Is it then fair that because she's been with somebody for 2 years, they get a slice of that? And I've switched the sexes round there purposely.
That was I noticed you did that. That was very good. No, I take the point. And I don't think there's a perfect system. I think
I don't
agree that as things stand, it's very imperfect. I think the prospect of any immediate change is, it's not going to happen. The government has recently rejected that, so we'll have to see what happens. But coming back to the here and now and moving away from our fairy tale land of sub-stories, I think perhaps it might be useful to finish on just reiterating to people just how they can protect themselves. So again, Lisa, let's go back to, and let's make it, you have a bloke this time coming to you because we want to be very fair on both genders. And he is about to buy a property with his new partner. What are you giving him in kind of headline advice about the things he might want to consider?
He absolutely needs to consider whether they're going to own it as joint tenants or tenants in common or in his sole name. They absolutely need to consider the contributions that they're making to that property, both now and in the future, and how they want that to impact any separation going forward. And that may mean that they have to have a declaration of trust drawn up. So it may be, for example, if he is going to be putting 80% of the deposit down and his new partner is going to be putting down 20%, then it may be that they decide that they're going to have a declaration of trust saying that if they separated, he gets back the first X amount. He's put down 100,000. He's going to get back the first 100,000. She'll get back the amount that she put down, and then anything over that will be split equally. So that's the first thing. Declaration of trust, be very clear about how you own that property. The second thing then is a cohabitation agreement. Do you want to have a discussion about more generally your finances, relationship, what's going to happen to the property if you separate, and do you want to have that recorded between you? We then need to be looking at making wills to ensure that you know what's going to happen to the property on death, and also considering things like life insurance as well, I think is quite important.
Yeah, absolutely. That's all really good, solid advice. And, that's, if you can follow those steps along, get things documented, make it clear, make it unambiguous, then you're really limiting the possibility of having incredibly complicated, incredibly difficult, and probably fairly expensive legal proceedings to resolve things at the end. Just very briefly, the last thing that I touch upon is I think it's been fairly doom and gloom in this kind of chat about when things go wrong at the end of the relationship. I've been talking about the court and talking about the statutory principles. We also talk a lot about alternative dispute resolution on this podcast, and those can still apply, and they're really, really great, particularly for Talata claims. Get it in mediation. You can do an arbitration. You can limit things and try and negotiate a settlement, because settlements are still where you want to end up. You limit the costs that you're spending on lawyers. No one wants to spend money on lawyers. And you can limit your liability to meet the costs of another part of your ex-partner if you end up losing. So getting things in mediation, trying to resolve things is still absolutely feasible, really advisable And the vast majority of tilata cases that I do tend to settle outside of court, or do you tend to get it into court and then you stay the proceedings to go off and mediate because the court really wants to see you do that. So, there are ways out. You can remain amicable, you can do things properly, and all those great things that we talk about all the time in terms of resolving your relationship breakdown with dignity and in as amicable a way possible.
Yeah, I think that's a really great place to end. And really, really helpful. Thanks, Matt. So that's it for this episode of Stowe Talks. Thanks for listening. If you would like more information on our podcasts, please head over to stowtalks.co.uk. And please don't forget to rate, like, share and review this podcast where you can.